Intellectual property rights, their protection and use in electronic commerce. Okay, you may have many times you may have heard about intellectual property and intellectual property rights. So what is intellectual property? The terminology means, see, this is product of any product of human mind is referred to as intellectual property. So it's a product or child of the brain. Okay, property of the brain is called intellectual property. So this is see, this can be in tangible or intangible format. That means it can be touched, or it can be in a format that can be touched, or that can be exclusively an idea that is an intangible, intouchable form. Okay, it is just in a format of conceptual form is allowed, and a physical form is also allowed. So that is about the intellectual property. So what is intellectual property rights? See, this is some exclusive rights granted by whom? Granted by the government to the creator or mender of that particular expression of ideas. See, this is expression of idea. Idea cannot be protected with the intellectual property right. Idea is something that is common, but the expression of idea, that matters. Okay, that expression can be in any format, written format, or video format, or audio format, book, photograph, design, etc. So that idea can vary, and that idea can be protected with the exclusive right. So this right is actually divided into mainly into three types. First one is copyright, second one patent, third one is called trademark or service mark. Okay, so these are extremely different in concept. Okay, copyright is granted by the government to mainly to some artistic work. Okay, for example, a song, a film, a serial, a YouTube video, okay, a book, a novel. Okay, so any content that is an artistic expression, it will be granted a copyright, and you cannot copy that content, and you cannot use it as your own. You cannot use it for making financial gaining. Okay, so you are copying some link of a video from YouTube and you are sharing it on WhatsApp. Is it a copyright violation? Is it a copyright infringement? Think of it. This is not a copyright violation. Why? You are not making any monetary payment from it. If you are making any payment from it by sharing or copying that video into some other location without the knowledge or permission of the creator or the mender of that particular content, you are sharing it and you are making monetary gaining. Okay, if you are making any monetary payment from it, that is strictly a violation of the copyright. This is called copyright infringement, and it is punishable under the laws, different laws. And second thing is patent. Patent is extremely different, even though they are collectively pronounced. It is extremely different. Patent is given for a particular person or to a particular company by the government whenever they have an innovative invention. Not just an invention, but that invention should be genuine, that invention should be useful to the people, then only a patent will be granted. So not for all inventions you cannot obtain patent. That patent could be exclusive and innovative idea, and that idea should help people also. Then only you will get a patent for a particular invention. So patent is for invention, copyright is for mainly for artistic work. And the third one is trademark or service mark. So this is mainly something to do with the businesses. So a trademark is associated with the businesses that deals with the products. Service mark is the same businesses that deals with services. So if you have a company that provides services only, you will get a service mark. If you have physical product that is being done as a business entity, then you will get a trademark. You may have, see, the trademark can be mostly a logo or a particular symbol that is allocated with the product or brand. Then you can make the guarantee. You can genuinely ensure that this particular product belongs to the original company. So that is the in order to ensure the genuineness, you have trademark. Okay, and the service mark is there for the businesses whenever their product is a service. Okay, so that is the difference between copyright, patent, and trademark. So any kind of violation or without the knowledge of the vendor or originator or creator, you cannot use this product without the knowledge of the origin. Even though I am having restriction in sharing some PDF files with you, which is available on the internet. Okay, because without their knowledge I am using it. But there is exception for researchers and teachers. And the second point is, I am not making any monetary payment from it, so I am not making violation. So there is strict rules and regulations which should be making us to compliance with. So we should be compliance with the in compliance with the all kind of such a patent and copyright and intellectual property regulations in our online activities. So beware of it. Okay, bye.